Welcome to Podcast 83, a regular look at the news, stories, and trends related to Michigan's 83 counties from the Michigan Association of Counties.
Good afternoon, everyone. Welcome to Podcast 83, podcast put on by the Michigan Association of Counties. Today I'm joined by Melissa Hagen from Cohl, Stoker, Toskey, who is a law firm that does a lot of county work across the state, including for us here at the Michigan Association of Counties. And today we're going to talk a little bit about a recent Supreme Court ruling that has to do with paid vacation time, PTO, sick time, and also a little bit with hourly wage workers. And I don't think we'll spend much time on the tip side of it because that doesn't affect us all, us at counties that much. But it is part of the overall arching decision that the Supreme Court made earlier. So Melissa, thanks for joining us.
Thank you, Steve. Thanks for having me.
No problem. Let's jump right into it. Before we get into where we are now, why don't we take a step back and how did we get to this point with the Supreme Court ruling and with these ballot measures and everything, and how did we get here?
Well, it all started back in 2018 when some advocacy groups got together and collected the requisite amount of voter signatures to get certain initiatives on the ballot. And specifically, they got two of them. They got one that had to do with sick time, and they got one that had to do with increasing the minimum wage gradually over time. But then prior to the election, the legislature adopted those proposed acts without change, without amendment. And so as a result, they're taken off the 2018 ballot. They become law. But after the election, the legislature amended those proposed acts, and they were signed into law effective, I think it was the end of March of 2019. But the amendments, they kind of drastically curtailed what the initiatives had proposed. So from there, the people that got together and brought this to a head filed the lawsuit. It took a long time because litigation takes a long time, but they filed it with the Court of Claims. The Court of Claims is the court where if you're going to sue the state, that's where you got to go. It's got its own specific court. So that's where they went. They got a favorable ruling, but the state appealed to the Court of Appeals. That takes another couple of years in the process. The Court of Appeals sided with the state, which led our advocacy groups to then go to the Supreme Court. So we get to the Supreme Court, everybody, all the parties file their briefs. It's a huge case. There's about 40 amicus briefs that get filed. The Supreme Court has to wade through all of this, but ultimately they reversed the Court of Appeals and they put back in place the ballot proposals that had been made back in 2018. So 6 years later, here we are.
Yeah, so the adopt and amend procedure that the legislature used had been something they'd used before, right? I mean, it's been used in the past, but I don't think it's ever been legally challenged. And then this time it got challenged. So we're at this point where the adopting part is okay. The amending part became what the Supreme Court said was not okay, correct?
That is exactly it. They adopted and amended in the same legislative session, and the court said, no, that's unconstitutional.
Now, are we at this point, since the Supreme Court has made this decision with regards to the paid sick time and the hourly wage, are we pretty much done with litigation at this point, do we think?
I think so, Steve. The Supreme Court did come out with a September 18th order that was clarifying its opinion that it issued in July. And that was as a result of motions filed by the Attorney General on behalf of the Department of Treasury and Laura related to minimum wage calculations, pretty much the mechanics of how that's going to happen. But with that order in place and nobody trying to appeal this case to the United States Supreme Court, I think we're done.
Yeah. Okay, so that gets us to today. Okay, so now looking forward as we start looking at the adoption of this ballot measure, where are we at now? What does this ballot measure do?
Well, all the counties are going to have to look at their sick time policies and revise those by February 21st, 2025 for their non-union employees. And then they're going to have to do the same thing whenever their current collective bargaining agreements end for union employees. The act doesn't actually displace the CBAs, but it will require them to be revised and comply with the act at the time that they expire. So what this means for counties is that they should have somebody, HR, their attorneys, whatever, review their current policies, because while many of them provide more sick days than the act requires, the act has some other points to it that employers may typically not include in their current policies. And one of those is that the act requires that sick time accrue. So you can't front load it. A lot of employers say, you know, on day one, you've got, 5 sick days. You can't do that anymore. You have to accrue 1 day for every 30 hours worked. The other thing counties really want to look at is the expanded use of sick time, which is now mandated by ESTA. And so, for example, now I can use, if I'm an employee, now I can use my sick time to go to a meeting at my child's school, if that meeting is related to my child's health. I can use my sick time to take my mother to her doctor's appointment. So those are issues that the county needs to look at. Those are issues that need to be in writing in their policies. The act has a specific section that says you, the employer, must put in writing these certain things that are now guaranteed to your employees. And then we've got, of course, the most obvious change, which is the increase to the minimum wage. And with a 3-year delay in the litigation, we're finally going to get these increases in the minimum wage, and they're going to be somewhat substantial. I think just a couple days ago, earlier this week, the Department of Labor and Economic Development announced 2 wage increases for 2025. On January 1st, 2025, minimum wage is going to go from $10.33 to $10.56. But then when the act becomes effective on February 21st, 2025, minimum wage is going to jump to $12.48 an hour. Now, I think probably counties have employees that are at that rate or above it in most situations. But for those smaller counties, or for, part-time employees, seasonal employees, they're going to have to start looking at those kinds of things. So it is time, probably in the next month or so, to get that in the works. Get ahead of the ball, get ahead of the game, get the ball rolling, and let your employees know there are notice provisions in the act. So let your employees know what is going on, keep them apprised.
Yeah, just to clarify or even go into a little detail, of course, this is not legal advice. We're not giving legal advice on this podcast, just to kind of update our members. But on the front loading component, is it fair to say you can front load as long as you are in addition to adding accrued paid sick time, or is that not allowed
Oh,
either?
no,
Because
certainly.
because to me it seems like if you're an employer and you're front loading sick time, that would be better for the employee, which I think the overall intent of this this enabling legislation was. So you can do the front loading, but you would still have to do the accrued sick time on top of that, correct?
That is correct. You can always do more.
Okay.
If employers remember one thing, you got to meet the minimum, but you can always do more.
Right. And then as far as the expansion of ability to use the paid sick time, when you say health, is there a definition of health? Is it mental health? Is it physical health? Is it both? Is there a definition given, or is that open to interpretation at this point?
No, it is very, very broad, actually. It's mental health, physical health. It is victim of domestic violence. It's a victim of sexual abuse. There are, and these things are spelled out in the act, Steve.
Mhm.
It's not a matter of interpretation. It's, a member's, it can be a family member's illness, injury, or any health condition. So, broad, very broad language.
Yeah, and with the date of enacting date, so these changes go into effect February 25th, 2025, unless you're under CBA, correct?
February 21,
Or
2025,
21, okay.
unless you're under a current CBA, yes.
And then should your current CBA is in effect until it expires. Then once that expires and you're going into negotiation, then those new negotiations would have to take into account these new enacted changes, correct?
Yes, that's absolutely correct. And one thing employers should know is that, a lot of CBAs say that it continues, the agreement continues in full force until a future date or event, i.e. like ratification. That language is irrelevant for purposes of having to include the ESTA requirements in your new CBA. Termination is termination. It's an end date, include the ESTA.
Okay. And then, of course, there's this caveat, right, that the legislature could still currently or before the February 21st date enact legislation that could change some of these things, correct?
Yeah, they can do that all over again and
Right.
send us into another tailspin.
Right. Which I know they're considering at this point. I
Yes,
think.
yeah, they have their proposals in front of them.
Yeah, and we've been working with some of the other business groups to get some changes. I think we're waiting to see what sort of draft changes come out of the legislature at this point. I know it's being talked about in Lansing. We're recording this in the beginning of October, but with a lame duck session coming up, it seems like this legislation would set up pretty well for a lame duck sort of possible change this fall.
This sounds very familiar, like 2018 all over again.
Right, right. Well, thanks. A great update. Is there anything else you'd like folks to take away that we may not have covered?
Well, I I understand that the legislature can change this again, but I think what counties and other employers need to be aware of is that workers want benefits that provide safety nets. And as demonstrated in 2018, they're willing to organize and use the judicial system to get those benefits. Because if COVID taught employees one thing, it was to be prepared for the many uncertainties in your career. And having sick time available to take a parent to a doctor's appointment, to go to your kids' school meetings. Those are important. Those are important to the employees, and obviously they have fought to get them. So just be wary, because a natural byproduct of increased workers' rights advocacy is workers' rights litigation. And that includes obviously lawsuits, grievances, arbitrations, and administrative proceedings. So, I guess take this seriously. Your employees have, and now it's time for the counties to do that as well.
Yeah, thank you for your time today, Melissa. I know we have an article about this topic coming up in our printed newsletter, which is coming out at the end of the month. We have an article on our website as well. If you go to our homepage, you can see the article is there. to provide even more detail than what we even covered today. So, and of course, you can always reach out to our staff here at MAC. You could reach out to Cohl, Stoker, Toskey, or we can get you in touch with them. But also your local advocates and attorneys on staff would be able to help. I'm sure they're up to speed as well. So with that, Melissa, thank you for your time today. Great update. I think you gave some great information. We appreciate it.
Well, thank you, Steve. Thanks for having me.
Thank you for listening to today's episode of Podcast 83.